Greetings, 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 greetings. It is I, your King, King Clifford Jefferson, ascendant of Godfrey, the fifth kind of band Jew, son of folk, ruler of Jerusalem. I am the reincarnation of King Edgar Jefferson, better known as King Edgar the Peaceful. I'm here again with my profession. My profession is English common law. So we know English common law goes back to time immemorial. We hear a lot of so-called teachers teach about it, but their study of the common law is wrong. They're deficient in the common law. Even the master scholars who went to universities were deficient. These words come right out of the mouth of William Blackstone. He held the first seat of an heir professorship in Oxford University. These colleges or universities, I should say, were founded in the Middle Ages by my ancestor, Henry II, son of Godfrey, the fifth kind of band Jew, who I am a direct descendant of. All right. Today is another marvelous lecture series. I know Archbishop mentioned that I should bring it or break it down in like 6-minute edits, but I can't dilute what's been given to me into 6 minutes. You know, so if you can only use your mind expansion to a 6-minute time limit, then you need some serious work. All right. If you can only pay attention to something for 6 minutes, you definitely need some help. You know, I didn't get this in 6 minutes, so why should I give it to you in 6 minutes? So I'm gonna give it to you in the manner in which I would give it to you. Once again, I didn't go to these universities, these colleges, these seminaries, these monasteries, these churches, etc. In the modern days, I went to schools of thought, which many of those who teach in this present day went through those schools. One of those schools is the Moorish Science of America, and one of those studentries were, in lieu of a few, Taj Tariq, which I had the privilege of sitting amongst when I was a member of the Moorish Science of America, Tipping Number 7 in Asbury Park, under the tutelage of Grand Sheikh Lord Nature El Bay. Peace to him, as well as peace to Brother Taj, peace to all those who identify with the identity as Moorish American. But nonetheless, the understanding about what's being taught to Moorish American is deficient in regards to this topic, which is called the corruption of blood. Once again, corruption of blood. I'm going to use Taj Tariq's lesson on how to reawaken the mind. Once again, it's not to discredit him, but it's to show those who view him. He's by far one of the most advised as well as learned men in this modern day in regards to what he's been a student of in his infancy. And that's one of the most important things about being a professor, as a professional at what you do. And that's based off the studentry, being a student in your infancy. And his infancy and his teachings comes out of the Moorish Science of America, under the tutelage of the Honorable Prophet Ali, peace and blessings be upon him. But he himself said, do not throw away your English surnames. He said the European will have to pay back in compound interest for what he did, for what the slave master did to our ancestors at the time of slavery. So with that in mind, you know, it's very important as a teacher and you being a student and being subject to the teachings as a student, wherever you're being taught at or taught from. And in this regard, I speak of the platforms. And majority of the platforms that you're being taught from in this modern day for those who identify with the terms Negro, Black, Cut, Ethiopian, Moorish American, Native American, Indian, etc. The list goes on. Majority of that is taught in YouTube. You know, so this lecture is for those who are in those schools of thought and to bring and bear witness to the deficiency of what's being taught by your leaders. and that's not by chance. It's very important to understand what's being said by your leaders, and because of the many followers that they have. And the House of Awakening Mind has many followers, and they do adhere to what's being said by their teachers. So what I have to do is, as being a student myself, because when those who go to school, you're not the only one sitting in that seat, and that seat is a very important station because of the importance, the novelty, as well as the public respect that you get from it, as being a teacher, and the teacher is only good as the student. And this goes for all those who are students or teachers, or those who claim to teach those teachers. And this list goes back to time immemorial, back to memory out of mind, and that's where majority of our teachers speak from, memory out of mind. We know under the common law, it's based off usage and customs, traditions, etc. And we know that when that usage and customs are erased or misplaced or lost, then the loss takes place. So when common law is dissolved, then written law becomes manifested. All right. So without further ado, I don't want to be long-winded, but this is going to be a long-winded class. To all those who are listening, please pay very close attention. I'm going to use as a narrative a lecture did by Taj Tariq Bey on how to reawaken the mind, and the topic of that discussion from an abstract discussion, not a concrete, what I'm saying, because corruption of blood, and the origin of where the term corruption of blood comes from the legal term bill of attainers or attainder, and he speaks about this in his video. Once again, I need those who are going to watch this video to pay close attention to what he says, in light of him not showing any type of written formal receipts to support what he's saying in regards to who he identifies this lecture to, which would be Moorish American. So please pay very close attention, because I'm going to break this video down so that all those who can view what's being said will have a concrete understanding versus the abstract understanding that you were being fed by many of the leaders, such as Taj Tariq, which is nothing wrong with the abstract understanding, because there's a lot of things that are being taught out of memory, out of mind, goes back to time immemorial, goes back to the time when we were not, so we need proof, and the proof is the written maxims, codes, and written maxims and codes and ordinances written by those who were historians of this time, going back to what we call the common law, where those terms were used in lieu of the corruption of blood. Because now in modern day, as a result of the corruption of blood, people are using these terms as if it relates to them as to people. And that is the corruption of blood, which calls for a bill of attainder, which results from what we call felonies or treason. Once again, felonies and treason. All right. Very important that you pay close attention. So without further ado, let's get started. I'm going to start with Taj Tariq lecture. I'm not going to play the whole lecture. I'm going to play about 30 minutes of it. If time permits, I'm going to stop just to pinpoint certain factors that you should focus on when I go into the concrete understanding of what's being said, as well as showing PowerPoints, which be my regular source, Wikipedia, as well as other evidentiary points, which are not subject to what we call the law of presumption. These are facts. You're going to hear him use this word fact all the time, but does not support one fact with what's being said. All right. And what's being said is based on what was said to him, which is what we call a record. All right. So let's get started. With always, I have to have my coffee, as well as give thanks to my ancestors, my wife, Queen Lisa Godwinson, as well as Archbishop Belmont from the House of Belmont, well as all those who are members and officers of the English Territory Church of England under our certificate of incorporation, which will be our charter. All right, so without further ado, let's get started. Shh, quiet.
Deeper and deeper I go. I find what
ancient mothers and fathers, work that has gone into the
Taylors. And welcome to House of Reawakening Minds. House of Reawakening Minds exists to provide for the exploration and practice of spirituality in an enlightened community dedicated to honoring the myriad of sacred pathways to the universal creator. We are a holistic center for spiritual grounding, free thought, self-discovery, and more science, an awakening experience for all ages. Tonight, I am pleased to present to you our National Grand Sheikh, Taj Tariq Bey, as he presents Corruption of Blood, a North Gate issue. But before he begins, please be sure to like, share, and if you have not already done so, subscribe to our channel. Now, let's receive Grand Sheikh Taj Tariq Bey.
Pay attention, y'all.
Islam. Assalamu alaikum, shalom, valimakum. We're going to discuss a little bit about corruption of blood. And it's important for our people to be aware of much of the work that has gone into the hybrid Europeans hegemony operations at North America under Unum Sanctions, that they have been encouraged to falsely and wrongly and incorrectly refer to as racism and prejudice problems and color skin problems. All of those dynamics and social engineering paradigms are in fact diversions, incorrect, non-constructive, deceptive, and birthright stealing in their nature. I want you all to write these words down so that after we have some of this conversation, that you can do a little research on your own to improve your concepts in relationship to the social engineering that has taken place in North America and has been exported around the world, etc., and be more confident with yourself in relationship to the honors of your mothers and your fathers, your ancient mothers and fathers, and the principles of the common law derived from the ancient customs and traditions of your ancient mothers and fathers that ties you to heritability.
Okay. Now, if we don't see any type of display or documentation, all we know he's reading from something. But we know he mentioned unum sanctum. That terminology is not related to English law, English history, or Morris history, or Morris law. It denotes to the Roman Catholic Church, all right? He also mentions the common law. Common law goes back to time immemorial, which is invented by Henry II. If you go back, if you look up time immemorial on Wikipedia, under the expression of time immemorial and law means going back to the time of 1189, which is Richard I. Richard I was the son of John, the son of Henry II, the son of Godfrey V, Count of Bantu, where I descend down from. So common law, or the history of common law, has nothing to do with case law. Common law has to do with the uses and customs and traditions of where the origin of common law come from. By no means am I saying that Moorish Americans doesn't have a common law of their self. All right, but he makes reference to common law to known here in North America and the origin of where it comes from. The origin of common law here in North America does not come from Morocco. It comes from England under English common law. All right, let's continue.
And so corruption of blood, I want you to look up these words: heritability, hereditaments, attainder, and also geography and land.
Okay, so he said, look up the words: bill of attainder, hereditaments, and geography and land, because geography means land. Hereditaments deals with an inheritance as beneficiaries to the land. When we say land, we're not talking about the real estate on the land or the lease estates, i.e. tenant, dealing with tenancy. We're dealing with either freehold or leasehold or lease estate. And freehold is the highest form of ownership in North America, but it's not allodial. For it to be allodial, you must have a radical title. A radical title is called a allodium title. But he's dealing with time immemorial concepts that has nothing to do with Moorish American or the history of Moorish American. All right, you must understand this. Hereditaments, bill of attainers, and geography. So let's do that. Let's look up bill of attainers. A bill of attainder, also known as an act of attainder or writ of attainder or bill of penalties, is an act of a legislator declaring a person or a group of people guilty of some crime and punishing them often without a trial. We're pretty much subject to that type of stuff today. All right, a trial without jury. This is a result of what we call bill of attainders, arriving from attainders. All right. So when you use this word bill of attainders and how a bill of attainder is used, you must go back to the history of where that bill of attainder originated from, which is from legislator, not from the Moorish American government, but from the English government, because the origin of bill of attainder starts from England. Let's read a little further. As with attainders resulting from the normal judicial process, the effect of such bill is to nullify the targeted person's civil rights. Did y'all hear me? Most notably, the rights to own property and thus pass it on to heirs, the right to the title of nobility, and at least the original uses, the right to life itself. This originates from ex post facto laws. Bill of attainders originate from ex post facto laws, from public and private laws that did not derive from the legislature. Y'all better hear me. In history of England, the word attainder refers to people who were declared attained, meaning that their civil rights were nullified. They could no longer own property or pass property to their family by will or testament. That's not the way property is supposed to be passed under the common law of England. Property being passed by under the common law of England is by what we call statute of descent and disposition. Once again, statute of descent and dispensation. I'm gonna show you statutes to qualify that, and I'm gonna show you case law to disqualify that. All right, let's continue. Attainted people would normally be punished by judicial execution, with the property left being escheated to the crown or lord rather than being inherited by the family. I repeat, with the property being left behind escheated to the crown or lord rather than being inherited by the family. So when property is escheated, it's only escheated in two ways: by a bill of attainders or as a result of intestate. Somebody dying, the heir is dying, and no more heirs there to reclaim the property. So therefore, it escheats to either the lord, the monarch, the crown. All right. In this case, it will be the state. And the state has laws called escheat, but it's not based off just regalia. It's based on what we call bona vacantia, which means unclaimed property. Unclaimed property. But first, to understand how the property is being taken from you, because he did mention hereditaments. Hereditaments deals with an estate, and the state deals with property, whether it's movable property, removable property, or immovable property, meaning property that can't be moved, such as land. Okay, the state don't have ownership of real property, i.e. land. It has rights over personal property, which is called abandoned property, or what we call, I just said the term, what they call it, abandoned property or lost property, or in the states have about what we call unclaimed property. That's what they call it, unclaimed property. All right. The first use of a bill of attainder was in 1321 against Hugh Lee Despenser, first Earl of Winchester, and his son Hugh Despenser, the young Earl of Gloucester, who were both attainted for supporting King Edward II. King Edward II was the King of England of the Plantagenet crown. Bill of Attainders passed and pardoned by Henry VIII on the 29th of January, 1542, resulting in the execution of a number of notable historical figures. Thomas Jefferson had a bill of attainder issued against him as a result of some creation of a pamphlet, which we'll talk about in a second if I have time, but we might not have time for the sake of what we discussed today. Let's continue on. Hope y'all paying attention. American dissatisfaction with British attainder laws resulted in their being prohibited in the United States Constitution. And in 1789, bills of attainders are forbidden to both the federal government and the states, reflecting the importance that the framers attached to the issue. Every state constitution also expressly forbids bill of attainders. The United States Supreme Court has invalidated the laws under the attainders clause on 5 occasions: Article 3, Section 3, Clause 2, and Article 1, Section 10. No bill of attainder or ex post facto laws are to be passed in lieu of the corruption of blood, meaning that the crimes committed by your forefathers. All right, what happened in that time is dead and gone. They're dead. So all that talk about reparations, you're not getting it. You're not getting it. You're not of the blood. You are violating the blood as a result of being classified as an American citizen. So therefore, that's why you're subject to Bill of Attainders, which are private and public laws being passed today. All right, let's qualify that. Apparently, Todd Sweet didn't do that. United Kingdom, English law. The word attainder is part of the English common law. Did you hear that? It's a part of the English common law. Under the English law, a criminal condemned for a serious crime, whether treason or felony, but not misdemeanors, which refer to less serious crime. Felony is a criminal crime, and treason is a violation of your allegiance. So every person who has an English last name is committed of treason. because you have broken your allegiance to the English common law, which could be declared attainted, meaning that his civil rights were nullified. This is why you have no rights, y'all. He can no longer own property or pass property to his family by will or testament. His property could consequently revert to the crown or to the menace lord. Guess who's the menace lord? The state. Every state under the Articles of Confederation are the landlords. They're the tenants who escheated your property as a result of the Bill of Attainder through public and private laws that are passed. Had nothing to do with the legislator at that time, because the legislator at that time, in which the Articles of Confederation under the Articles of Confederation made up of the 13 Confederate states, were subject to the ideological laws that they were created under the Constitution of the Articles of Confederation. At their time, they were under the legislative of the crown. Under the crown, under just regalia. All right, we'll discuss that in a second. Once again, the convicted person would normally be punished by judicial execution. When a person committed a capital crime and was put to death for it, the property left behind is ceded to the crown or lowered rather than being inherited by the family. Attainters function more or less as a revocation of the feudal chain of privilege in all rights and property thus granted. So all property was taken away or ceded to the state as a result of all the heirs being denied their nationality, their birthright, all right, as a result of being reclassified as American citizens, which you happily accepted by declaring yourself an alien to the laws of this land, the supreme law of the land, which the founding fathers recognized under the Articles of Confederation, which was the common law of England. All right, let's go a little further. Unlike mandatory sentences of the courts, acts of parliaments provided considerable latitude in suing the punishment to a particular condition of the offender's family. Parliaments could also impose non-capital punishment without involving courts, such bills called bills of pains and penalties. So every time you brought into court, it causes pain, it causes penalties as a result of you being ignorant of law. Concrete law, law that's in court, not law going back to some abstract story relative to what we call a birthright, which has been taken from you as a result of you not knowing the origin of what we call Bill of Attainders and how the Bill of Attainders acquired, being acquired by those who put the Bill of Attainders on you and therefore extolled your birthright through achievement by declaring you intestate. All right. Bills of Attainder were sometimes criticized as the convenient way for the king to convict subjects of crimes and confiscate their property without bother of a trial and without the need for a conviction or indeed any evidence at all. All right, so when we were enslaved by the British Parliament and under the authority of the king, we were property. And that's the position that Dred Scott found himself in. All right, the same position that Dred Scott found himself in. Let's move on. The Great Act of Attainder. In 1688, King James II of England and the 6th of Scotland, he was not the first king of England. He's just the first king who had the first name James, sitting on the King English throne. They wasn't worried about the Scottish throne and the Irish throne because the Irish and the Scottish throne were already united through the plantation of Ulster, which was created by King James, which is where the Protestant descended down, which is the Quaker broke away from as Protestants. All right. It says that in 1688, King James II of England, 6th of Scotland, 7th of Scotland, driven off by the ascent of William III and Mary II in the Glorious Revolution, came to Ireland with the sole purpose of reclaiming his throne. After his arrival, the Parliament of Ireland assembled a list of names in 1689 of those reported to have been disclosed to him, eventually tallying between 2,000 or 3,000 in a Bill of Attainder. Those on the list were to report to Dublin for sentencing. One man, Lord Mountjoy, was in Bastille at the time and was told by the Irish Parliament that he must break out of his cell and make it back to Ireland for his punishment, or face the grisly process of being drawn and quartered. All right, that was the penalty under the Bill of Attainder to attainder. All right, under the authority of the English common law as set forth by the English king. The King James only brought the practice of Bill of Attainders going back to time immemorial under English kings. All right, through private bills. Everybody see that? Through private bills. Private bills are private and public bills not created from the legislature, because the legislature is not the private bill. The only bills that are private, which was those created by presentment of what we call the president. In this case, the president is head of the state, and he's acting as the assumed de facto monarch. All right? Everybody needs to understand that. Taj is not teaching you this, or anybody else on their platform teaching you this. So please understand. All right, let's go further. Attainder. In English criminal law, didn't say Morse law, didn't say Spanish law, didn't say any other law, but English criminal law. So if you talk about a bill of attainder and you're not making a reference to English common law, then that's treason. Not just by those who teach it, but those who follow it. In English criminal law, attainder was the metaphorical stain or corruption of blood, which arose from being condemned for a serious capital crime such as felony or treason. Changing your allegiance. Y'all better hear me, Moorish Americans. As you ain't got Moorish names and you were born with these names given to you by your mother and father, you better pay attention. If entailed, losing not only one life, property, and hereditary title, but typically also the right to pass them on to one's heirs. Both men and women condemned of capital crimes could be attained. Attainders by confession resulted from guilty pleas at the bar, before a judge, or before the coroner in a sanctuary. This is the same practice that are being practiced today. But the origin goes back to the Middle Ages. So this is being practiced on you as a result of you lacking the understanding of the origin of why they've been put on you in the first place as a result of your treasonous act. Middle Age and Renaissance. Very important, everyone. Very important. Right here, which you're talking about Bill of Attainders or attainder. Henry VII, the founder of the House of Tudors, initially attained men after he has ascended to the throne. Everybody listen. He used the threat of attainder as a means to keep the few nobles who survived the War of the Roses in line. The War of the Roses was a result of the Yorks and the Lancasters, which were cadet branches of the Plantagenet crown, had nothing to do with Moorish Americans, had nothing to do with the British crown, had nothing to do with the New France and New Spain, because they all descended down as a result, all came to be about as a result of what transpired as a result of what we call the War of the Roses. Y'all better question your leaders. Charles I, Charles II. Listen to this. In Westminster system, a bill of attainder is a bill passed by Parliament to attain persons who are accused of high treason, or in a rare case of lesser crime. Persons detained need not have been convicted of treason in a court of law. One use of the attainder process was a method of declaring a person a fugitive. Another was applying collateral consequences of criminal conviction, especially property forfeiture. where the subject had died and could not stand trial for that reason. A rumor circulated that the bill of attainder against Thomas Jefferson occurred in 1774 because of his authorship of the Summary Review of the Rights of British America. Let's just hit that for a second. Because he got the last name Jefferson, and Jefferson is Godfrey, goes back to plantation the crown. So what was Thomas Jefferson's problem if he had the surname Jefferson? A Summary Review of the Rights of British America was a tract written by Thomas Jefferson in 1774. This is the time of the Articles of Confederation, y'all. France said that the 13 colonies under the Articles of Confederation through the first and second Continental Congress had committed treason against France as a result of them being financed by France, as well as the assistance that France gave them in lieu of their war against Great Britain, i.e. the British kings. The Summary Review of the Rights of Britain was a tract written by Thomas Jefferson in 1774 before the U.S. Declaration of Independence, in which he laid out for the delegates to the First Continental Congress a set of grievances against King George III, especially against the King and the Parliament of Great Britain, response to the Boston Tea Party. Jefferson declared that Parliament did not have the right to govern the 13 colonies, right? Because they were under the Articles of Confederation with France. He argued that since the individual colonies were founded, they were independent of British rule. Everybody hear this? This is the Treasonous Act. Jefferson in this work held that allodial title, not feudal title, was held to American lands, and thus the people did not owe fees and rent for the land to the British crown. Thomas Jefferson, once again, said that the land here in North America is not free and simple. It's allodial. All right, it's allodial. If it's allodial, then there must be a radical title. Let's just look at a radical title. I should be pulling this up, my subjects. You should be pulling this up, my heirs. If you have an estate here left in the trust and you are the beneficial owner, then you should be looking this up. Radical title is a concept of English common law. Didn't say Moorish law, didn't say Spanish law, didn't say any other law but the English common law. And English common law originated under the invention of Henry II. All right. Radical title is a concept in English common law that refers to the crown, underlying title to all land held in overseas plantations and colonies, i.e. the 13 colonies. It grants the crown the power to alienate others from the land and to transfer beneficial ownership of the land to itself or others, but it does not grant beneficial ownership. So that means that if you're not an heir, you don't have the right to this land because you are an alien. All those who colonized North America, as well as those who were immigrating to North America here, called America when it was under the jurisdiction prior to becoming United States of America. It was called British America, and British America was under the authority of the crown, not the Moorish American, because the Moorish American government is not the crown, nor was, nor is, nor will it ever be. All right. Now, if you watch the video, Todd said in one of his videos that he was getting a permit for a allodial title to a parcel of land. How could you have a permit for a allodial title of a parcel of land? If all those who watch that question, that's the question you need to ask him. All right, so let's go back to the video.
Now, many of these words, most of you are aware of the true meanings of many of these words and phrases that have been used, not necessarily in the general public arena, of the rulers and the corruptors not wanting the common or the average people to be aware of their corruption, their trickery, their misrepresentation, and their general established frauds in all of the institutions. It's unfortunate, but you have to recognize that all of the institutions of government, for the most part, are corrupt from the top to the bottom. It may be difficult for many of our people to accept that, but that is indeed the truth. The other issue is, don't get caught up in the paradigm of comparing gods and fighting God's upper gods and lower gods game. Because all of your major religions have been contaminated by the P2 Masons of the Vatican or Rome, etc. And at the same time, don't get confused with the fact or the reality that Masonry itself as a study and Freemasons as an organized body are two different issues. No different than people who have been doing most of the evils on the planet have been using Jesus as a front. You don't blame Jesus for the fact that it is implying justice and that Jesus implies the son in the sky of the creator and the creative forces, and also of light and love, and the demonstration of a moral and ethical being, period. Don't confuse that with the fact that people bandy that name around and claim to have power. The history and the fact has been proven and shown and demonstrated that most of the people who have been the greatest beneficiaries, both economically, politically, and socially, bandying about Jesus, 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 have been some of the most corrupt people that the world and the planet has ever known. However, that is not to condemn those who are in honor and in goodwill and good intent have made their associations with Jesus or the principles of Jesus as presented to the people, even though it's, for the most part, been presented in an anthropomorphic format. No.
See that? Everything he said from the time I restarted the video is abstract talk. All right? Nothing concrete. Nothing concrete to substantiate anything in reference to the form where these talks should be taught about. All right? You as a student should be questioning what's being taught as a result of the form that he's teaching in, because that's not a legal forum. It's not a university that teaches law. He didn't make reference to one law or show any law reference to a bill of attainers or the origin of bill of attainers in regards to how the property is being escheated from the heirs, dealing with the rights of hereditament. So let's deal with escheatment, because this deals with what's being taken from you as heirs of the estate. Escheat is a common law doctrine that transfers real property, not personal property, real property of a person who has died without heirs to the crown or the state. So the only two parties that has the right to real property, not personal property, in lieu of the term escheat that origins come from the common law, is the crown, because the state origin does not come from the common law. The origin of the state comes from the modification or the changing of the word state from confederates or colony. So the true owner of the land under the term escheat is the crown, because the Confederate states or colonies were subjects of the crown, and everything that the Confederate states owned was subject to the crown under allodial property, all right, under the radical title of the crown. This is not being taught by Taj, nor is it being shown by Taj or anybody in any form in reference to declaring an estate for a people, denoting to heirs who are beneficiaries. It serves to ensure that property is not left in limbo, y'all, without recognizing the ownership. It originally applied to a number of situations where the legal interest in land was destroyed by what we call operation of law, statute of descent, and dispensation, so that the ownership of the land reverted to the immediately superior feudal lord. This is what's going on now, because they're transferring the estates by will and testament under what we call fee and simple, where it's no longer under the entail estate that was left by the grantor, i.e. the heirs who we descended down from, under the authority of the crown, under entail estate, because the crown is entail estate. It's called crown land. I'm not going back through that because we've already visited. All right. The term escheat derives ultimately from the Latin excadere, to fall out, via medieval French escheat. The sense is of a feudal estate and land falling out of the possession by the tenant in possession of the lord. Everybody understand that? Everybody see that? Everybody needs to question that. Origin of escheat. Background. Did Todd give you a background? No. Background of the term escheat, which means to falling out. Origin goes back to the time of the Norman conquest of England in 1066. All the land of England was claimed as the personal possession of William the Conqueror under the allodial title. William the Conqueror invaded England in 1066. He was a Frankish king who aligned himself with the kings of Wessex, the last king being William Edward the Confessor. Edward the Confessor were kin to the Plantagenet crown through Margaret of Scotland, who married Henry I, son of William the Conqueror, and they followed the laws of Edward the Confessor, and Edward the Confessor was the son of Ethward and Ready, the son of Jesus Christ. All right, the son of Jesus Christ, who I'm the reincarnation of. So as Todd said, people are throwing that name around and not understand the purpose of the term Jesus Christ, which is the threefold office: a prophet, a priest, and a king. A prophet is a spokesman, a priest is an elder, and a king is a kindred. I qualify for all three. All right. The monarch thus became the sole, i.e. corporation sole owner of all land in the kingdom, a position which persists to the present day. All right. Thus, under the English common law, there were two main ways escheat could happen. There's only two ways they can take your property. One, not being no heirs left, or two, bill of attainers. Only way. A person land escheat to the immediate overlord if he was convicted of a felony, but not treason. If that event, the land was forfeited to the crown. If the person was executed for felony, his heirs were attained, i.e. were ineligible to inherit. In most common law jurisdictions, this type of escheat has been abolished outright. For example, under the United States, under Article 3, Section 3 of the United States Constitution, which states that attainders for treason do not give rise to posthumous forfeiture or corruption of blood. Posthumous means reward after death. All right, reward after death. That's the only way a escheat can happen, if a bill of attainder as a result of what we call treason or felony. And the United States Constitution, Article 3, Section 3 states that, as well as the state's Constitution, Article 1, Section 10. The other way is what we call intestacy. All right, too. If a person has no heir to receive his land under his will or under the laws of intestacy, see statute of descent, dispensation, then a land he owned at the death would escheat. This rule has been replaced in most common law jurisdictions by bona vacantia, or a similar concept. A similar concept for bona vacantia is what we call unclaimed property, y'all. Unclaimed property, which the state has authority to oversee as custodians. Not own, but oversee. All right? Let's go back to Taj's video.
Nevertheless, the goodwill and the honor and the good intent of the people takes them from the darkness into the light, nevertheless. And source or Allah in nature, divine or divinity, recognizes sincerity and honor in people, no matter from what walk of life they come. And our ultimate goal and our ultimate intent with our relationships with each other is to do good, to be better to each other and to ourselves, and to remove from humanity the lechery and the parasitic nature of the dark side of the people who have been ruling this planet for quite some time, to the negative of both the planet and of the peoples of the planet. Now, corruption of blood in its nature, I'll give you a short in law, and then we'll do an extension, but I want you to pay attention to the abbreviated presentment in ancient and modern jurisprudence. And as you know, jurisprudence means the science that treats of positive law. And when you're dealing with the fundamental principles of jurisprudence that has been promoted for the most part around the world, is based in ancient Coptic or ancient Sabian Moorish law, and that is true. And they'll just say Coptic or ancient Egypt to cover it up, etc. Now,
okay, he has not proven that. He has not shown that. He's trying to relate under the common law to a term that's considered abstract, because there's no common law to support uno sanctum or ancient Gupta or the ancient Moabites in reference to some legal standing in a court of law, ruled by judges in lieu of that usage that was in existence before the common law, i.e. the written law originated, as termed by modern day scholars, judges, etc. All right, this must be questioned. Let's go back, continue.
When you're talking about the styling of the Constitution for the operations of government at North America as an example, you'll find that many people who know the metaphysical origin and nature of the Constitution for the United States of North America know that it did not originate with Madison, George Washington, or John Thomas Jefferson, John Adams, or Thomas Barclay, who was agent in business when they were adopting from the Aboriginal Anansi Confederation of Moors at North America, who they traditionally write in history as Indians, which you already know is a diversion in itself. That those principles are ancient principles that underpin the nature of the Constitution for the United States, etc. So don't look at it as originating with the hybrid Europeans. Look at it from a realistic point of view of them adopting the principles of that Constitution for governance, etc., in the intent or in the promise of honor and integrity in governing. However,
okay. So he mentions Native Americans in regards to what needs to be reflected in the understanding pertaining to what he's talking about, according to the situation that we are now in. All right, but there's a problem with that as a result of the classifications where he's trying to classify us, right? Because under the common law and the traditions under the common law, it originated with Anglo-Saxons, not Native American Indians. Native American Indians are not Anglo-Saxon because Anglo-Saxons were the original mound builders here in North America. You can find them here in Western North America as well as Eastern North America, under the new classification on what they call Native American Indians. Not Native Americans, but Native American Indians. One of those terms are Native American tribes were called the Lenape. Now check this out. This is dealing with the Lenape Native Americans. Everybody needs to pay attention. By 1682, a Quaker, William Penn, arrived to his American Commonwealth. The Lenape had been so reduced by disease, famine, and war that the sub-clan mothers had reluctantly resolved to consolidate their family to a main clan family. This is why William Penn and all those after him believed that the Lenape clan had always only had 3 divisions, turtle, turkey, and wolf, when in fact they had over 30 on the eve of the European contact. Members of each clan were found throughout the Lenape territory. And while clan mothers controlled the land, the houses and the families, the clan fathers provided the meat, cleared the fields, built the houses, and protected the clan. Upon reaching adulthood, a Lenape male would marry outside of its clan. That's abolished through law. The practice effectively prevented interbreeding, even among individuals whose kinship was obscure or unknown. This means that a male from the Turkey clan was expected to marry a female from either the Turtle or Wolf clan. His children, however, would not belong to the Turkey clan, but the mother's clan. This is not agnatic succession or primogeniture, y'all. It's not. As such, a person's mother's brother, the person's matrilineal uncle, played a large role in his or her life as they shared the same clan lineage. With a marriage itself, men and women have relatively separated in equal rights, each controlling their own property and debts, showing further signs of woman power in their hierarchical structure. The woman's hierarchical structure you still see displayed in the British monarchical system, as well as the influence on the English monarchical system, which was based on the patrilineal. Primogeniture monarch system was based off the male. Okay, it was called spirit-sided versus what they call distaff-sided. We went to that already. As in the case of the Iroquois and the Susquehannock, excuse me for pronouncing wrong, Susquehannocks, part itself. The animosity of differences and competitions spanned many generations, and generally tribes with each of the different languages group became traditional enemies, and they aren't in the areas they met. On the other hand, the New American Book of Indians point out the competition, trade, and word relations were far more common than outright warfare. But both large societies had traditions of proving bloodying new or young warriors by counting co-op on raids into another tribe's territories. The two groups were sometimes bitter enemies since before recorded history. Did you hear that? Since before recorded history. But intermarriage occurred, and both groups had oral history suggesting that they jointly came east together and displaced the mound builders' culture. So the mound builders, i.e. Native Americans, are not the same as Native Indians. I repeat, the mound builders from Mississippi and Mississippi mound builders are found here in what we call the eastern part of North America, because the Lenape were located here in North America as well. Look at that. And in North America, i.e. New Jersey was one of the Confederate states, i.e. Jersey, which flew this flag before George Carteret and John Berkeley had it, by the charters given by Duke of York by Charles II, son of Charles I, who was married to Henrietta Marie of France. All right, so everything that was done was in violation of the common law as well as stereotypes, which I'll show you in a second. All right, let's go back to Taj.
History has shown, and the record has shown, and the experience has shown that those who have been governing not only have deceived the people from the beginning, and also had no intention of maintaining the honor and the integrity of that contractual constitution or its principles. Because keep in mind this, that the principles underpinning that constitution belong to the people by nature, having nothing to do with the written instrument itself. That must be clear so that you don't think that that Constitution itself in its written form gives you or secures any of your rights. Those rights unalienable belong to you divinely, and the sovereignty that goes with it belongs to you from divinity in nature herself, having nothing to do with any written instrument, for you yourself are the law and master of your fate.
Stop. Once again, that's a lie, because the crown holds a radical title to this land. I'm going to show you by case law. Case law are derived from the depositors of the law and the depository, which is the record. Where Taj is not a depository of the law, nor is what he's talking about as from the depositories of the law. All right, we must understand that, because corruption of blood is a result of bill of attainders. Let's just prove that again. Attainder. Corruption of blood is one of the consequences of attainder. The descendants of an attained person cannot inherit either from the attained person whose property has been forfeited by the attainder. This is called foreclosure, or through their other relatives from him. For example, if a person executed for a criminal crime leaves innocent children, the property of the criminal is forfeited to the crown and will not pass to the children. If criminals' innocent parents outlive their child, the property inherited by the parent from the criminal cannot be inherited by the criminal's children either. Instead, it will be distributed among other family members. The United States Constitution prohibits corruption of blood as a punishment for treason. Specifically, no attainder or treason shall work corruption of blood or forfeiture except during the life of the person attained. So only corruption of blood through a bill of attainder can only result from the person in which the attainment was presumed to be put on. All right. My ancestors, English people, never had bill of attainders put on them or put on any person of their ancestry. That only came through what we call the War of the Roses, when we were fighting amongst ourselves as a result of influences through marriages. The woman, all right, of a different family class status. All right, not talking about the woman is bad, but based off passes down in the state, how it's supposed to be passed down through patrilineal, not matrilineal, as the founding fathers of the common, under the common law, has established to be. The United States Constitution prohibits corruption of blood as a punishment of treason. Specifically, no attainder or treason shall work corruption of blood or forfeit except during the life of a person's attainted. And when Congress passed the first federal crime bill in 1790, it prohibited corruption of blood as punishment for any federal crime. So now it's okay now. It's okay now to corrupt the blood. It's okay now. It's not okay. It is not okay. Let's go back.
And so when you hear us say Islam, I, self, law, and master, that's what that means on a metaphysical level, and not necessarily what most people assume from a ritualistic, dogmatic, or creed position, but from a position of recognize the divinity in all living things and in nature herself, and our obligations to each other and to all living things in living forms upon which original religious principles are founded, etc. Having no recognition of secularism whatsoever. Keep that in mind. So corruption of blood in its nature of law is the attainder activities that has been commonly practiced at the North Gate. And keep in mind, geographically, North America is known cosmologically and according to the ancient ones as the North Gate. And you're dealing with the four gates of the earth. So you got the North Gate, the South Gate, East Gate, and West Gate. And so you're dealing with the geography of Midgard, this particular planet or firmament, based on its cosmological relationship with the stars. Now that's true. And this is why when you go into...
This is not the Avengers. This is not Thor. What the heck is Midgard? Middle Earth, the North Gate. These are not legal terms where the origin of corruption of blood derived the term from. So if this is what you think the origin of corruption of blood comes from, in reference to what Todd is talking about, then you're at the mercy of your teacher, who is deficient in the understanding of the common law. He's deficient, y'all. Let's just look at just regalia. Let's look at unclaimed property. Bona, vacantia. Unclaimed property, lost property, mislaid property. Unowned property includes tangible physical things that are capable of being reduced to being property owned by a person, but are not owned by anyone. Bona vacantia for ownerless good means ownerless goods. It is a legal concept associated with the unowned property which exists in various jurisdictions with a consequently varying application, but with origins mostly in English law. So it has nothing to do with Midgard, Uno Sanctum, or any of that stuff that Todd is talking about in regards to property being escheated as a result of bill of attainder, which started from corruption of blood. And corruption of blood did not start with these myths that Todd is talking about in Midgard. Has nothing to do with it. Bona vacantia is dealing with unowned property, which falls under the jurisdiction of where the state comes in, all right, versus just regalia. Let's get a look at that. Jura regalia. Right, so I pronounced it wrong. Jura regalia is a medieval legal term which denotes to rights that belong exclusively to the king, either as essential to his sovereignty, such as a royal authority, or by accidental, such as hunting, fishing, and mining rights. Many sovereigns in the Middle Ages and later time claimed the right to seize the revenue of a vacant episcopal see or abbeys claiming a regalian right. All right, this is the right of the church, not the state, because under the crown, it was called a state church. It was a fusion of government. It existed all the way up till 1776, when Queen Anne was under the monarchy. It was de facto in nature, but still, nonetheless, it was a monarchy. All right, so. Jura regalia. It is difficult to determine when and where the jura regalia was first exercised. In the West Frankish kingdom, it made its first appearance probably towards the end of the Carolingian dynasty, that is, in the course of the 10th century, okay? In England, the exact practice prior to the Norman conquest of England in 1066 is unclear. But for monastery, it is likely that the bishop or the prior administered the estate and that the revenue did not go to the king. Under King William the Conqueror, the record is also unclear, but the absence of monastic complaints suggests that the revenue did not go to the royal treasury. Let's go a little further. Let's go right here. During the reign of Henry II, 1154 to 1189, i.e. time immemorial, it has become an established practice for the King of England to take the possession of the revenue of all vacant dioceses, although the king generally allowed a division of revenue between the actual monk and the abbatial officers, and did not administer or touch the monk's income. Revenues from the regalian rights were normally paid into the exchequer, who would record it in the pipe rolls. Okay, so this goes back in regards to the dealing with the what's the term we were reading? Cover it. The authority that the king has in regards to the revenue took him by way of what we call escheatment. This is the revenue that the king has the right to as a result of his authority under what we call jura regalia, under his sovereignty. All right, we need to understand that. And the origin of all that we're talking about today, that Todd to speak back on the platform, comes back to English common law. Right? English common law. New Jersey Revised Statute 46:30. This act should be known and may be cited as bear with me, y'all. It's a big statute, long statute. Give me a second. Oh, here we go. Short title. All right. You're going to hear Taj in a second talk about bona vacantia, which is the unclaimed property. And he said through bill of attainers, as a result of achievement in escheat, all the property are now sitting in museums as a result of it being deemed as unclaimed property, as a result of the heirs claiming that the heirs just left it. All right. He's going to actually say that. All right. I have a statue here showing you that the museums have made claims due escheatment now under the authority granted by the state, and now have the authority of ownership. All right. As a result of interstate, the heirs not claiming it, and do bill of attainers, there's nothing we can do about it to this day. To this day, there was nothing we can do about it until I came upon the scene. And I'm going to show you how we're going to do something about it. I'm doing something about it right now. Let's go back to the video.
All of the ancient culture, you will see that all of the layouts of civilization are based on metrology, which is a mathematical connection of this firmament that we call Earth here, Midgard, in relationship to the constellations, in their relationship to the direct and angular connection or views from the position of Midgard, Earth, etc. So cities have been laid out by those principles. Customs and culture has been laid out or adopted from those principles, And that is the foundation of the religions, etc. And this is why you will see this.
Stop. That's a lie. Those cities, towns, bureaus have been laid out by what we call land registry. Under civil ordinances and codes, under the encumbrances of the laws of the state through the eminent domain power of the state as a result of escheatment. It had nothing to do with the nature's law, nothing at all.
The sun, the moon, and the stars used as signs in all of the original religions, not to be confused with the corruption that has taken place by the priesthood since the founding of religion. And so religion, as it is in its corrupted form, would be known as dogmata. No different than the priesthood has deceived the whole world and removed the cosmological alchemical metals, which are the money, and have introduced it as a substitute their private commercial paper, commonly known as Federal Reserve notes, upon which they have used to enslave humanity, aside from the dogmata, etc. So when you're looking at or really examining the political platforms that you're forced to deal with, and I repeat, forced to deal with, because you haven't consented to any of this crap, etc. The organized government body are actually at North America, board of trustees. So the people that you have been calling, the presidents, praetors, etc., and the congressmen and the senators, men and women, have all actually been operating as trustees or board of directors and FOFers for the crown, which would include all of the Pharisees and Sadducees, which you know as the attorneys, the esquires, and lawyers, etc., which are in fact known as the crown, who have been organizationally running all of the judicial systems in what is known politically as the Western government systems, etc. And so
that's a lie. That's a straight lie. If you don't question that, then you believe that all your authority was stolen by the crown. No, it was stolen by those lawyers who usurped the crown and the intel estates under the process of what we call common recovery. Common recovery has been abolished, but we keep the practice. Not me, I'm fighting against the process, but you keep the process up by ignorant statements like this that he just made. Let's look up the crown. I already spoke about this. Todd is telling you about the crown. I'm showing you. Crown land, sometimes spelled crown land, also known as royal domain, is a territory area belonging to the monarch. It didn't say attorney, it didn't say a lawyer, it didn't say a bar member, it didn't say none of that crap that Todd is talking about. It says that the monarch who personifies the crown. The monarch is the king. They're talking about Jesus Christ now. They're talking about the incarnation, the personification, the manifestation of the representation of the individual person who sits in that seat. And it must be a natural person, a corporation soul. Crown land, also known as royal domain, is a territorial area belonging to the monarch who personifies the crown. We know what personifies means. Personify means to incarnate. All right, that's what it means. Personify, to act exactly like, to bring it into existence. It's the equivalent of a intel estate. It didn't say fee and simple. It says an intel estate. An intel estate is an inheritable estate and passes with the monarchy, being inseparable from it. Did everyone hear that? That's crown land. Now let's talk about the crown, because Todd said the crown was a bunch of lawyers. The crown. I'm passionate, y'all, so just forgive me. The concept of the crown as a corporation soul developed first in the Kingdom of England. It didn't say the Bar Association. It didn't say law school. It didn't say none of that. It said it developed first in the Kingdom of England as a separation of the physical crown and the property of the kingdom from the person and personal property of the monarch. It spread through English and later British colonization and is now rooted in the legal lexicon of all 15 Commonwealth realms. There are various dependencies and states and free associated with them. It is not to be confused with the physical crowns such as those of the British regalia, because the British regalia is not the jura regalia. The jura regalia is the authority that the crown has over the overseas possessions known as the colonies, which we are subject to now, i.e. now called states. So it has nothing to do with our members of the Bar Association because they're an aggregate corporation and not corporation soul. A corporation soul is a natural person. Let's review that. A corporation soul is a legal entity consisting of a single soul incorporated office, i.e. Personified office, i.e. What's it called? Incarnated office, meaning I have to incarnate it to the position of that office through my studentry as a student of what that seat represents pertaining to that office, i.e. the professional, being a professional at what it requires of that office, all right? So the office of a corporation soul is not for that of the status of a corporation, it's for that of a status of a natural person. The structure allows corporations, i.e. religious corporations, or Commonwealth government to pass without interruption, i.e. perpetual. The crown is perpetual from one office holder to the next, given the position legal continuity with the subsequent office holder having identical powers and possessions to their predecessors. A corporation soul is one of two types, a corporation and the other being corporation aggregate. The origin. Now, the origin is now being assumed or presumed to associated what people who are talking about the term the crown and how they understood it to be the state by these deficient students and now professors of the law, trying to claim themselves to be master scholars, but they're not master scholars. They're deficient in the scholarship of why the university was created in the first place, because the origin of the university goes back to the origin of the creator who owns it. All right, so let's go back to Taj.
In general, if you're referring to United States corporation company that has been occupying North America, Canada, Germany, etc., these would be referred to as Western nations. And we're not talking about the geography, in fact, of the organic land, but a political nomenclature used to demonstrate or to indicate operations in their political jurisdictions, both civil order jurisdictions and political constructions of nation states and the corporate nation states known as the Occidental stock of the human race, etc. Usually referred to as loosely Europeans and more specifically hybrid Europeans, and falsely referred to since 1854 as quote unquote white people.
Let's stop there. White people, Caucasians, all right, 3 white persons. Europeans, Caucasians, 3 white person, Naturalization Act of 1790. How the founding fathers turned themselves had nothing to do with the identity, had nothing to do with the study of the ethnicity or the genealogy of the people who lived at that particular time. Let's qualify that, shall we? Let me find it. Bear with me. Bear with me. Like that. Let's see what's there. I don't think I'll pull that up. That's Melrose. Where is this? Bear with me, y'all. I might not find it, y'all. No, I don't think I'm gonna be able to find it. Forgive me for that. I'm not gonna be able to find that. So let's just go back to the video. And while the video's playing, hopefully I'll find it.
Condemnation of the hybrid stock, it's just to let you know the politics that you're operating under, willingly or unwillingly, that has corrupted the whole planet, i.e. has become a severe problem of the North Gate, and particularly to the Aboriginal Canaanite Moabite peoples of Asiatic African origin, etc. Here at Northwest Africa, known as the North Gate, commonly referred to Al Marak or America, Amir, etc., etc., etc.
Okay,
now,
I got it.
Keep in mind.
All right, let's go ahead. All right, let's look at this, y'all. This is dealing with 3 white persons, Europeans, based off the Naturalization Act in 1790 for the classification of those people there known as the founding fathers, how they identified themselves, because they themselves had nationalities, all right? They had a nation, they had a country that they came from, where laws governed them. And as a result of them violating their law, that was the result of what we call treasonous act. It was a treasonous act that the colonies committed, not against their own country, but against the crown, all right? They reclassified themselves as free white person, all right? But the free white person had nothing based off the classification to deal with that denoted to some type of ethnicity or genealogy. Now everybody's trying to be classified as free white person when it has nothing to do with ethnicity or genealogy. It's just a classification identifying those who came up with that term. It had nothing to do with an ethnicity genealogy. It had to do with skin color. All right, let's just look at it through this case. This case is Enway Ahmad Hassan. He was trying to classify as under the status as a free white person. And this is the opinion or the decisions of the judge. Once again, let me just go up, show you the case. Enway Ahmad Hassan, 48 F point supplement 843. This case was heard in 1943 in the United States District Court for the Eastern District of Michigan. All right. Everybody listen. To summarize the approach which must be followed in deciding whether a particular person applying for citizenship is a white person within the meaning of the statute, as interpreted by the Supreme Court, it is necessary to determine first the particular group or racial subdivisions to which the individual belongs. Once again, to summarize the approach which must be followed in deciding whether a particular person applying for citizenship is a white person within the meaning of the statute as interpreted by the Supreme Court, it is necessary to determine first the particular group or racial subdivision to which the individual belongs. So everybody who claims to be a citizen in North America must ask themselves the same question that this case is revealing in regards to being classified as a free white person, which is in the case of Ahmad Hassan, that his name, Ahmad Hassan, all right? Let's go on. In practical effects, proof of this fact is a matter of genealogy. In practical effects, proof of this fact is a matter of genealogy. An individual who presents an aberration from the color of skin of the group of which he is a member, such as a light-skinned Chinese or Japanese or dark-skinned Anglo-Saxon, does not thereby acquire different status under the act from the other members of his group. Of course, when an individual applying for citizenship has a skin of a different color than is usual for the members of the group from which he claims to come, a strong burden of proof then rests upon him to show by the usual methods of the proving genealogy that he is in fact, a member of that group. After the individual has been traced into his group, the second question which the court must answer is whether the member of the group as a whole or a white person, as Congress understood the term in 1790 when they first enacted the statute. In deciding this latter question, the test is not how the group in question would be classified by ethnologists who have made a study of racial origin, but rather what the group of people then living in 1790 with characteristics then existing were intended by Congress to be classified as white persons. Did you hear that? So the classification under the Naturalization Act of 1790 had nothing to do with ethnicity or genealogy. In regards to the examples that he gave you, such as light-skinned Chinese and dark-skinned Anglo-Saxon. And if you do classify for any one of them, you first must meet the first criteria by proving it by ethnicity and genealogy. Then two, you must balancing on the meaning of the creation of the statute of the Naturalization Act as refers to those people at that time the act was created, referring to the people at that time, such as those white people pertaining to their color of skin. All right, their color of skin. And they say anything about Moorish American, and they didn't say anything about Spaniard. They gave only two examples: light-skinned Chinese and dark-skinned Anglo-Saxon. Y'all all heard of Cheddar Man, right? Found in Somerset, Somerset, England, and what they call Cheddar Gorge. All right, these were those who were buried in these megalithic structures called tumuli or tumulus, who were barrel mounds, which were chambers for the dead, and memorial in memory of our ancestry. I've spoken that in the first video, the lecture on the mound builders. I'm about to do a part 2, so pay close attention. So let's go back to Taj's video in regards to the different groups of people here on this continent in reference to a color of skin, in reference to identifying themselves with the administrative government that was founded in the 1790s, in reference to the founding fathers, and how those individuals, such Moorish American, fit into that scope of their identity as free white persons or Europeans, as decided in this case in reference to people claiming to be free white persons, which we are not, because it does not fit the requirement as stated in this case, in regards to first proving ethnicity and genealogy, then second, the meaning as reference to the meaning of the act in reference to the Naturalization Act of 1790. Okay, so in light of that, let's go back to Taj's video.
The last lawful name or attribute used to apply to all the Asiatic African people or the Aboriginal peoples, i.e. of the world, of the planet, is Al-Moroccan. In short, known as Moors, etc. That's a fact. And you will see.
That's not a fact. He has not produced one fact on that platform whatsoever in regards to the status of those considered to be the terms you make relevant to based off their color of skin. Because under the framers' mind, the people with that color of skin, known as dark-skinned, does not denote to the characteristics in that act or statute known as the Naturalization Act of 1790, which Todd is making reference to, because there's no other act he can make reference to in regards to the people relative to the state that was stolen by way of corruption of blood. All right, y'all better understand what I'm saying to y'all.
In the ancient, before the transfer or before the descendancy attributes have been used, we generally refer to as Moabite, etc. And so when you see in the Septuaginta and in the ancient Coptic text, or any text that make reference to Yeshua, and you'll see Yeshua translated, and it's not a transliteration either. You'll see them refer to Yeshua as Jesus, etc. And so Jesus was Moabite. He had hair like lamb's wool, skin like burnished brass, like copper, as if burned in an oven. And you'll see the books refer to his grandmother, Ruth the Moabitess. And so, in short, the descendants of the ancient Moabites are referred to as Moors. They are the people of Asiatic African descent who have hair like lamb's wool in general, although they come in many what they call coats of many complexions, etc. They are the direct descendants of the ancient Moabites and are the founders of the first civilizations on the planet Earth, etc. And the capital dominion is known as Escheat, and Escheat is known in the modern terms as Egypt, etc. And so this is why when you go into much of the social intercourse that you'll find in the earlier records in the mid 1800s and back, you'll hear them reference the mid territories of North America.
He didn't say Midgard though, did he? He said mid territories. That's the middle colonies. He did not say Midgard, because Midgard has no affiliation or nor connection to any estate here on planet Earth. You have to go to the what they call Asgard, what's called Asgard for that, and we ain't on Asgard. All right.
As Little Egypt, etc. And you'll find it in many political statements, etc. And so you have Upper and Lower Egypt, and the concept that people have when it's taught, the history of geography is taught to the people by the hybrid Reconstruction Europeans. They're thinking only on the east side of the planet of ancient Amexem, modernly referred to as Africa, and they're thinking of Nubia and Sudan, etc., Eritrea, etc., and Hikupto, what you call Egypt, and they're looking at the top and the bottom of what they refer to as the Nile, etc., when they make reference to Lower and Upper and Lower Egypt. But in reality, Upper and Lower Egypt includes that side of the water, even into North Central South America on this side of the water of the Great Atlantis, which used to be a great river. And of course, those of you who know some of the history of Midgard know of what is known as the continental drift, and or the cocoa plate shift, etc., which expanded and caused what you would call the Great Atlantic Ocean. And know that the people of ancient Canaanite and Moabite descent on both sides of the water are of the same blood and are the same people of different tribes. Keep that in mind. Now, the corruption of blood has much to do with the conquest of the Asiatic African peoples under the unum sanctum operations of the popes of Rome, even up into what they call the Spanish Inquisition. And in your modern histories, when they make references to Spanish or Spain, etc., keep in mind that is a contemporary term in the history of man, having nothing to do with the peoples or language, but has to do with the cover-up of Moorish history. And this is where,
once again, that's a lie. You're using code words to explain actual historical events that are recorded on the record. What he's talking about is reference to geographical territory that was governing here in North America, because he's here in North America. He's not over in Spain. North America was governed by Spain and France prior to the British colonization, getting their territory as a result of the surrender of the Dutch territory, which goes back to conflicts that were originated here in the Anglosphere and Anglo territory. All right, so you really have to understand what's being said to you, because you, as the people who are listening to him, are really dark-skinned Anglo-Saxons. And we have to prove it, not based off some abstract story going back to time immemorial, which there's no written record to support, but we have to prove it based off the record that was recorded in the events decided by case law based off those uses and customs of the people who lived at that time, which was the example that was gave in the case law, dark-skinned Anglo-Saxons, i.e. Cheddar Man. Had nothing to do with Moorish American at all, because it's not the history of the common law of the common people. Let's continue.
Some of the hybrid Europeans in their wars with the Moors, named Al-Andalusia, that you know today as Spain in Europe, which is actually a part of the northern coast of the African empires, etc., and claiming it as being separate and refer to it after Ferdinand and Isabella did their nuptials. They refer to that area as Spain. Know that that is Al-Andalus, and also know that in the history and in the nature of Asiatic African culture, that the feminine and the masculine principle in nature is acknowledged even in the language. So you will see al-Andalus and al-Andalusia, which still is al-Andalus, etc. So when you see al-Andalusia and al-Andalus, you're still referencing the geographical area of the what you call Iberian Peninsula area, that you know as Spain, Portugal, etc. And
called the Kingdom of Iberia, which bears the flag of Saint George, a German saint. All right, he didn't tell you that. I spoke about that in previous classes. All right, the Kingdom of Iberia. Write that down, look it up.
And Portugal is actually the port of the Gauls, which is actually an African tribe. So keep in mind the hybrid concept that the people have of Portugal being one of what they refer to of the linguistic group of the Latin linguistic group of hybrid Europeans. No, that land is Port of Gauls. So the Port of Gauls are Central African tribes that come up, etc. So is France, etc., and the linguistic group. Now that's the reality and part of the truth of the human, or the walk of man that's not taught to the people. However, that knowledge is preserved among many of your secret societies, and this is why Masonry has been corrupted by the Freemasons, i.e., which are generally hybrid Europeans who are descended from the conquest operations, including the Knights Templars, etc., in their wars with the ancient Canaanites, Moabites. They'll refer to us as Carthaginians.
Stop. The Knights of Templars goes back to the 11th century with Godfrey of Bouillon from the House of Flanders. That's the written history that is presumed to go back to what Taj is talking about, but there's no record to support the history that Taj is talking about. But there's a history to support the Holy Sepulchre, which was founded by Godfrey of Bouillon under the Roman Catholic jurisdiction by Pope Francis. All right? That has nothing to do with the English throne or English territory or English land or English customs and traditions that was happened to be ruled in Jerusalem at that particular time under Godfrey V, Caliban Jew, Father Folk V, ruler of Jerusalem, head over the kingdom of Jerusalem. All right? He has no clue about what he's talking about.
They'll also refer to us as Saracens, etc., so don't get it twisted. While they've used different attributes over the years, much of it is done only to hide you from the real illustrious history and also from the reality that they have put in attainder, i.e., upon the true heirs of the land or the aboriginals of the land.
Okay. Once again, he's using that word, bill of attainder, on the aboriginals of the land. The origin of the bill of attainder has nothing to do with the aboriginal people of the land, because the aboriginal people of the land only got their charter that was subject to the crown. Somerset versus Stewart. Y'all have to pay attention to what's being said and not always agree with what's being said without contesting it.
And thus the corruption of blood. Now, so in law and jurisprudence, the corruption of blood would read like this.
He's reading but not
Corruption
showing.
of blood. In English law, the consequence of attainder.
In English law, not Morris law, in English law. So how is it that under bills of attainder, that under escheatment of the property that belongs to the heir, because no heirs exist? He didn't say Moorish Americans, because when he say heirs, he's making reference to Moorish American heirs, but the Moorish American heirs property wasn't escheated by bills of attainders under Moorish law. It was done by bills of attainders of English law, going back to the War of the Roses. The War of the Roses does not compose of houses of Moorish Americans. It composed of houses of the Plantagenet, which was the Lancasters in New York, which fell under the authority of the House of Tudors under King Henry VIII, which put everything in the trust under the English Reformation of the Church of England. All right, Todd has no clue.
So write that down, attainder, A-T-T-A-I-N-D-E-R. It's very important for you to have this concept. Being that of an attainted person could neither inherit lands or other hereditaments. Write down hereditaments. That's H-E-R-E-D-I-T-A-M-E-N-T. Repeat. H-E-R-E-D-I-T-A-M-E-N-T-S. Now, hereditaments deals with all inheritance, both corporal and non or incorporeal. All right, so you're dealing with both the customs, the traditions, and then you're dealing with the physicalities, whether you're dealing with lands, furniture, artifacts, etc. And because of the corruption of blood, this is why you see the hybrid Europeans have always practiced digging up all the graves of all the Asiatic African people and claiming the artifacts to be their own and putting them on display in museums and generating finance from them.
Unclaimed property, bona vacantia. Unclaimed property. They can't claim the land because they don't own the land, because the land is subject to what they call jura regalia under what we call a radical title. A radical title is also called a root title. Look it up. Radical title, root title. Radical title, root title is a title held by the crown. All right, let's look at it again. Radical title is the concept of the English common law that refers to the crown underlying title to all lands held in overseas plantation colonies. That means that the land is allodial. Everybody hear that? The land is allodial. All right, let's go back.
Etc. And then disconnecting the real people from the truth of the dynasties or the ancient dynasties at Midgard, etc.
There you go, talking about Midgard.
Is a corruption of blood, etc.
Let's stop now.
So
I didn't heard enough.
I'll read the list.
All right. Now, Taj is teaching y'all the origin of the corruption of blood as a result, or as a reason, for bills of attainder being put on the subjects, which in return, that which was left for them in the trust, i.e. in the state, has been escheated to the sovereign state, because the sovereign state is not the crown and the crown is not the sovereign state, according to how they're being identified today. All right. So you must understand that under jura regalia, that this authority, in lieu of all escheated property which does not fall into the beneficiary as a result of what we call intestate, automatically escheated back to the crown, which is crown property, which cannot be separated by the crown because the monarch represents the crown as corporation soul. Todd's not a corporation soul. He doesn't hold any office in reference to preserving the estates that was a beneficiary estate called a cestus quae for heirs that he claimed the Moorish Americans are. He has not proven one fact, but I will. Dean versus Association of New Jersey's Company, 1853 case by the United States Supreme Court. The soil under the public navigational waters of East Jersey belonging to the state and not to the proprietors. This court so decided in the case of Martin versus Waddell, and the principles covering a case where land had been reclaimed from the waters under the act of the legislator. This action of ejectment was brought to recover a tract of land, i.e. a state in the land, at Paulus Hook, now in Jersey City, on the Jersey Shore, formerly under the tidal waters of the Hudson River and below the low water mark. The locus in quo had been reclaimed from the water by the artificial means and was in possession of the Jersey Associated and occupied by them as a building lot under what we call easements. And the easement is a non-possessory right and property that don't belong to you. Cos never showed you that, did he? Let's go to what I want to get to. Let's start here. It says here, it is true, the defendants claim, they talking about the Association of New Jersey's company, right? It is true, the defendants claim nothing more than an exclusive right of planting and growing oysters on the soil for which the ejectment was brought. The special verdict found that he was in possession under a law in New Jersey which gave him the exclusive privilege of planting and growing oysters on the premises in question upon the payment of certain rents to the state, i.e. encumbrances. The principal question, therefore, and dispute between the parties in the suit, and indeed the only one of any value, was the oystery fishery. But the right to the fishery depends on the right to the soil upon which the oysters were planted and grown. And if the plaintiff could have shown that the properties under whom he claimed were legally entitled to it, the judgment of the court must have been in his favor. Nor do we see anything in the opinion delivered on the occasion in relation to the right of fishery further than they can contribute to illustrate the character and object of the charter to Duke of York, and to show that the soil under public and navigational waters were granted to him, not as a private property to be parceled out and sold for his own personal emolument, but as part of the jura regalia with which he was clothed, and as such were surrendered by the proprietors to the English crown when they relinquished the powers of the government and consequently belonged to the state of New Jersey when it became an independent sovereignty. Now, under Title 59, New Jersey by statute, New Jersey waived their sovereignty and a present-day statute, and they're deemed as individuals and corporations and can be sued in the same capacity and results of torts. So New Jersey don't have any sovereignty, but we just said right here, New Jersey claimed the sovereignty of the crown. What sovereignty of the crown did they claim? It wasn't jura regalia, because that was reserved for the crown. The only property they had in regards to that belonged to the crown was that of what we call abandoned property known as bona, vacantia. Let's prove it. State by the Attorney General versus Standard Oil Company, 1950. Supreme Court of New Jersey. All right. The primary question here, as delivered by Judge J. Heir, the primary question here is the constitutional sufficiency of Chapter 155 of the Succession Law of 1946, as amended by Chapter 357 of the Succession Law of 1947, which is called the Escheat Act. New Jersey Statute indicate 2:53-15 at sequence. This is called the Escheat Act of New Jersey. And we all know what escheatment is. when you have the ability to claim all the property as a result of intestate. All right, no heirs being here. So New Jersey has passed a law under the Escheatment Act as qualified by New Jersey Revised Statute Annotated 2:53 as features, providing for the escheat in certain circumstances of money, negotiable instruments, chooses and actions, interests, debts, or demands due to escheated estates, stocks, bonds, deposits, machinery, farm, crops, livestock, fixtures, and every other kind of tangible or intangible property and the accretion thereon, but excluding real property or property and custodians, legates, and unclaimed bank deposits made subject to escheat by Chapter 199 of Session Law of 1945, New Jersey Statute Annotated 17:9-18 that sequence. All right. So New Jersey has passed a law governing the escheatment of personal property called abandoned property under the Latin term bona, vacantia. All right. Now let's see where this goes. $296. Y'all better pay attention. 296. Under our law, to right to interpose the bar of the statute of limitations to actions and contracts of this class is vested property right which the law-making body may not abrogate or impair. It is fundamental that the denial of a remedy affects the substance of a right in the constitutional sense. When the remedy is taken away, the right ceases to exist. So a right to reclaim property as a result of what we call a statute of limitations is not a constitutional statute at all. All right, we're going to validate this. The conception of the bar of the statute of limitations as vested rights of a defense beyond legislative impairment was not abrogated or modified by the Constitution of 1947 of New Jersey. Pertinent provisions of the Constitution of 1844 were reenacted without substantial change, and it is to be presumed that their retentions constituted the adoption of the quality and meaning accorded to them by the long set of judicial construction. There is no substance to the contention that under the Constitution of 1947, the Escheat Act limits the operation of the statute of limitations, even to the point of divesting an accrued right to defense under its provisions. The argument in that these statutes, having lost all force and vitality upon the abrogation of the Constitution of 1844 by the adoption of the Constitution of 1947, again came into full force and effect simultaneously by virtue of their wholesale reenactment under paragraph 3 of the new Constitution. And so they must be read together and reconciled. And therefore the Escheat Act is not subject in any manner to the statute of limitations. Did y'all hear that? The Escheat Act is not subject to any manner to the statute of limitations, but the mere continuance of these statutes by constitutional fiat is not indicative of a purpose to abrogate vested rights to defenses permissible under the statute of limitations. There is no suggestion of a legislative design by the original enactment to annul the bar of the statute of limitations and revive in favor of the state a debt or demand that inter partes had lost its vitality by the operation of the statute. The Constitution of 1947 does not give the statute a radically different quality and meaning. All right? Radically or radical means root. Check this out. In the modern usage, escheat signifies the falling of property to the sovereign for want of an owner. All right, so that means when unclaimed property, i.e. bona, vacantia, which falls under the laws of the state, not the crown, because the crown claims it by what we call escheatment, so that the property don't fall in limbo, which we read in the previous excerpts that we read on Wikipedia. All right, it said, but also, let me read that again. In modern usage, escheat signifies the falling of property to the sovereign for want of an owner. And this category embraces not only property which has no other owner, but also property whose owner or whose owner whereabouts is unknown. Under the common law of England, escheats came to be classified as another branch of the king's ordinary revenue. Blackstone's commentary 302, what was originally an incident of tenure is now an incident of sovereignty. The doctrine of escheat at the earliest common law operative only upon that which was the subject of tenure, since it related to the reversionary right of the lord to take for want of a tenant, was eventually extended to include personal property as well, tangible and intangible. Todd said that in the lecture. The principle was that the right to take that which belonged to no one appertained to the crown as jura regalia. Jura regalia. The crown steps in to take the property because it is vacant. Property described as bona, vacantia, i.e. unclaimed property, is taken or assumed by the state as its own. Property of this class falls to the crown as a matter of right to exercise of its sovereign power. Did y'all hear me? In personal estates which are allodial by law, the king is the last heir where there is no kin. I repeat, concerning personal estates which are allodial by law, the king is last heir when there is no kin. Let's go to unclaimed property to validate this in the United States. Bona vacantia was inherited from English common law and continues in the form of lost, mislaid, and abandoned property. Apply only to personal property that has left the owner's possession, as opposed to estates left in intestacy after death. So the only way escheatment can come about is by bill of attainers and intestate, meaning heirs died and automatically seeks the crown of the state, or by bill of attainers. And bill of attainers result from felonies or treasonous acts. All right. Bona vacantia was inherited from the English common law and continues in the form of lost, mislaid, and abandoned property. Apply only to personal property that has left the owner's possession, as opposed to an intestate left in intestacy after death. Intangible personal assets such as checks, account balances, and securities are under unclaimed property law, varying by state. The state does not take permanent possession, but acts as a custodian of the property in perpetuity on behalf of the rightful owner. So there's a way to get your property back, but you must be the proper owner. As I proved under just jura regalia, the only owner of the two property, real estate, personal estate, what it says, what's the other term child use? What did he say? Well, whatever he said, all property is under the authority of the crown, which is a right under the crown as a right of corporation sole. Corporation sole own it because it's an entail, which means that it cannot be separated from the person who represents the crown, i.e. the corporation sole, i.e. the king, which I represent. All right. Through my certificate of incorporation, which you call a charter. All right. Let's go back to case law to validate it with another case. So we just read, we just read Dane versus Association of New Jersey. Dane versus, this is now. Yeah, we read State of Parsons by the Attorney General. It says that as stated, let me just reiterate. Once again, in personal estates which are allodial by law, the king is last heir where there is no kin. We're talking about radical titles. All right. That's a radical title or jura regalia. All right. Radical title or jura regalia. Let's go to State versus Otis Elevator Company. Let's see the same language. Where is it at? Down further. Right here. And modern, let me just show you. This case is Otis, State versus Otis Elevator Company, which is read Dean versus Association, as well as State versus by Parson versus what is it, State by Parson? State by Parson. Now this is State versus Otis. And modern usage is chief signify the falling of property to sovereign for want of the owner. The category embraces not only property which has no other owner, but also property whose owner or whose owner with whereabouts is unknown. Under the common law of England, escheats came to be classified as another branch of the king's ordinary revenue. Blackstone validates that, and he states in closing, the crown steps in to take the property because the property is vacant. Property described as bona vacantia is taken or assumed by the state as its own for custodian purposes. Property of this class falls into the crown as a matter of right in the exercise of the sovereign power under what we call radical title, a radical title through what we call jura regalia. All right. It's also said in personal estates which are allowed by law, the king is the last heir where there is no kin. So in closing, let's go right here. This is the article, Radical Titles of the Crown and Aboriginal Titles. All right, this is page 268. Once again, the article is called Radical Titles of the Crown and Aboriginal Titles. Everybody pay close attention. And considering of Blackstone's formula, it is not at all surprising that inconsistent policies, i.e. public policy, private policy, i.e. public and private laws, were adopted by decision makers at the point when British sovereignty was proclaimed, and later by judges scrutinizing the basis for those assertions of sovereignty. Did English law, including radical titles, automatically apply in new colonies as the birthright of British subjects, regardless, incidentally, of whether they hailed from England, Wales, Scotland, Ireland, or other jurisdictions within the United Kingdom? Question mark. Whether plantations of North America and the later colonies in Australia and New Zealand properly claimed by occupancy, by conquest, or by treaty? Question mark. That is not a question for which clear answers are available even to this day. So in Blackstone's and William Blackstone's time, as well as his present day, nobody can answer these questions to this day, i.e. August 31st, 2023, by your king, King Clifford Jefferson. When Blackstone wrote on the uninhabited country, did that mean a stretch of territory totally devoid of human persons? Or rather, was the focus of British policymakers' attention on whether the inhabitants whom British settlers had discovered were capable of owning property, for which the test would be locked in, for which the test would be Locke's notion of cultivation and labor as the base for private property rights and without regard to indigenous conceptions of connection to land and country. Did you hear that? Why did he say that? Because Blackstone, the author of Blackstone commentary, stated in this commentary that those who studied under professors of law, which at this time, Blackstone studied in, what's it called, Pembroke, Oxford University, which was chartered by King James. He said, even as a master scholar, that all the scholars who stepped before him were deficient as a result of the cultivation of imperial laws that were modified and amalgamated with the common law which you have today. But that does not take away from the uses and customs of that common law that goes back to time immemorial before it was written and what we call legal maxims and codes by those who became the master scholars or the historians, which are now being taught. And you have the mercy of your teachers. So with that, I close with the concept of time immemorial. I have to put this work in for y'all. See, I'm speaking about the time Tariq can't go back to. All right. His usage is contrary to the origin of the ancient law of the usage that goes back before memory of mind, memory of record, memory of the record of mind, of men. Men mind can go back to the memory of the record, going back to that ancient and traditional laws, going back to time immemorial, because according to those who teach it, it's abstract. Because it has no reference to law. And law, time immemorial, denotes a period of time beyond which legal memory cannot go, and time out of mind. Most frequently, the phrase time immemorial appears as a legal term of art, and judicial discussion of common law. Remember, a discussion about the usage, traditions, and customs of the people who lived under that common law. Not what the historians wrote about the people who lived under the common law, who were Native Americans under the rights that Native Americans had, not classified Native American Indians. So in law, the time immemorial denotes to a period of time beyond which legal memory cannot go, and a time out of mind. Most frequently, the phrase time immemorial appears as a legal term of art and judicial discussion of common law development in the United States, the property rights of Native Americans. The time immemorial is frequently used to describe time required for a custom to mature into the common law. Did you hear that? Time immemorial is frequently used to describe the time required for a custom to mature into a common law. Most of you who have common law, i.e. your customs, don't have the time put in to mature to become established as a common law, according to how time immemorial is established under the courts of law. Common law is a body of law identified by judges and judicial proceedings, rather than created by a legislator. Judges determine the common law by pinpointing legal principles consistently reiterated in previous legal cases over a long period of time. Very important. In closing, in English common law, time immemorial ends and legal memory begins at 1189. Todd, I hope you're watching this video. In English common law, time relative to immemorial ends and legal memory begins at 1189, the end of the reign of King Henry II, who is associated with the invention of the English common law. Who is King Henry II? King Henry II. Father was, he was from the House of Plantagenet. Father was Godfrey Plantagenet, Count of Anjou. where I descend down from. All right. That's why you see the 3 flags standing behind me. So I am the reincarnation of your forefathers. And I encompass all the teachers that your forefathers created that were preserved in what we call the universities where your master scholars learned that. Taj Tariq is not a master scholar, nor is he a student of those universities, because if that, he will be telling about the gods who are now being remembered through these lessons that I teach you today. And with that, I say peace.